this past summer,
This past summer being summer
2022.
of 2022. Okay, so that's a separate argument, Your Honor. They want to bring in some, as substantive evidence, some alleged encounter between Mr. Altheimer and Mr. Harris that occurred over a year later. That's not even remotely relevant.
Mr. Gross, final word.
Sure. That the summer 2022 incident is relevant to his credibility because it's an attempt to witness tamper. That's, I think, a rational argument from what Mr. Harris is going to testify Mr. Altheimer was doing.
That is not a rational argument. If they think there's a case of witness tampering here, they should have called the police and turned this alleged witness tampering incident over to the police and the prosecutor's office.
This is before the court on the defense motion for the court to reverse or partially reverse a prior motion in limine. Mr. Harris was not present and has no personal knowledge about the incident that's this case on January 27, 2021. The defense initially indicated that it was seeking to call Mr. Harris to impeach Mr. Altheimer's testimony that was made here in this court. At least if the court's notes are correct, the impeachment concerns that Mr. Altheimer may not have been driving with headlights on the incident with Mr. Harris, that Mr. Harris presumed or assumed, or his opinion is that a newspaper might have looked like a gun and a threat, and that Mr. Altheimer was potentially knocking, Mr. Harris's opinion that there was a loud knock on the door early in the morning. All the rest of what the defense said is substantive evidence. It's not for impeachment, and most of what the defense said, Mr. Altheimer was never asked about on the stand. So it's really about substantive evidence. With respect to substantive evidence, much of what the defense discussed is really improper character evidence, indicating that Mr. Altheimer, on a different situation, was a bad person doing bad things, that he was trying to intimidate individuals. That in and of itself, for character evidence, is not admissible under ER 404A and B. The rest of it, is some of it relevant to the issues before the court in this case? It's hard for the court to see that, but even if it is, we really get to ER 403. And what the defense has proposed with respect to this information is just really confusing the issues in this case versus some prior incident, maybe some prior bad blood between Mr. Altheimer and Mr. Harris that really has nothing to do with this case. It's confusing. I think it's a waste of time, and it's so far afield of what the jurors are expected to decide in this case that I think it would be error for the court to allow this testimony to be admitted, because it really has nothing to do with this case. And because the court's concerned about the potential improper 404B aspects of it, the defense request for the court to reverse or partially reverse its motion in limine is denied. Mr. Harris, unless there's more, will not be permitted to testify in this case, either for impeachment purposes or for substantive evidence, for the reasons the court has given.
Thank you, Your Honor. Ms. Serrano has a motion as well.
Oh, I still want to hear from the
sorry.
defense.
So what the court's finding is that while you agree that certain of what Mr. Harris would testify to would be impeaching the credibility of Mr. Altheimer, that it's too distracting to the jury to admit it?
The defense went far afield from its initial impeachment only, and it doesn't sound like defense, that your offer of proof was way beyond impeachment, and so that's just, impeachment's appropriate for the couple of items that I identified on here, but that's not what you're asking the court to do. You're asking the court to allow a whole series of events not related to this incident be relayed by Mr. Harris, and that's not what the court's going to allow.
We'd remove under a way narrower scope to the impeaching items that the court mentioned, as well
What
as
specific questions then do you want to ask with respect to that are impeaching questions of Mr. Harris?
the three that the court mentioned. The newspaper under the sweatshirt, the fact that he was driving with his headlights off, and the fact that he pounded on the door, which Mr. Altheimer specifically said he did not do, And the fact that he did not say that night to Mr. Harris, would you like a newspaper? He left a note, and what he did was leave a note that said, courtesy of TNT, now F off.
Well, that's far substantially narrower that you're asking the court to permit than what was in the offer of proof.
Yes, it is.
So are you modifying your offer of proof?
Yes.
State.
Sorry, taking notes. Your Honor, impeachment has to be a contradiction on a material and not collateral matter. Whether or not the headlights were on, I think that is collateral, and I think that whether or not was aggressive or non-aggressive is just a matter of opinion, and whether or not a newspaper could be viewed by him as something other than a newspaper is, again, a matter of opinion, and I think that it is too minor and collateral of an issue to bring a witness in to say, well, it was a note, not a verbal offer to subscribe to the newspaper, or a verbal question to subscribe to the newspaper.
Yeah, with respect to the headlights, it's my understanding that there may be testimony that, at least is somewhat of an offer of proof, but I realize Mr. Troy doesn't have to testify, but if he does testify that in fact he saw Mr. Altimer drive up and not have headlights on some driveways, and that alerted him to suspicion, and Mr. Altimer did testify that he always leaves his headlights on. So with respect to the headlights on or off, that would be proper impeachment, regardless of whether it would be, well, Mr. Troy doesn't have to testify, but there would be evidence that the jury could hear that Mr. Altimer is untruthful with respect to whether he always drives with his headlights on, and he said always. I made sure to make a note of that, and those always, never questions can be can open doors, and I think it's proper impeachment for the headlights. With respect to the newspaper maybe looking like a gun, loud knocking, and the time frame of that was admitted, and so and there's no question Mr. Altimer's credibility is key in this case. So impeachment of those, the state's correct in that they may be a minimal fact with respect to what the jury consider and the overall part of the case, but that doesn't mean the defense shouldn't be able to say, well, Mr. Altimer told you this, we have another witness that told you this. At this point, why would you believe either witness? Again, impeachment, not that you should believe Mr. Harris. I want to be real clear about that, because that's substantive evidence. So if Mr. Harris says his headlights were off, the argument to the jury is not, well, Mr. Harris told you the headlights were off, and so that means he has them off. It's that you cannot believe what Mr. Altimer says based upon what Mr. Harris may have said. So counsel needs to be careful with this, because impeachment argument often, I mean, you're all very skilled lawyers for sure, but most of the lawyers I deal with are newer lawyers, and it's a fine line between, well, I asked A and the witness said B, and then they argue to the jury, well, B must be the truth, because when it's an impeachment, it just shows A or B, two stories were told, and you shouldn't know who to believe. And I have no reason to believe counsel would do anything improper during closing, but that's why I keep asking, is this for impeachment or substantive evidence? Because if it's substantive, there's a whole set of evidence rules that are going to come into play. If it's impeachment and the argument is only that you shouldn't know who to believe in this case, that's different. And so with respect to the limited offer of proof or the modified offer of proof, the court's going to allow the defense to call Mr. Harris to talk about those items that we've talked about for impeachment purposes, but not for substantive purposes. I understand you may need to set a little bit of the scene on this, and I would grant some leeway because it's not going to make sense otherwise. But if you start getting into Mr. Harris, well, I saw something suspicious, well, that's not impeachment anymore. Now you're trying to say that Mr. Altimer was doing something suspicious in the neighborhood, and that's substantive evidence the court's not going to allow. So while impeachment's permitted, it's got to be really narrow with respect to the questions that are asked of Mr. Harris, and he's not going to be able to go far afield, as I've indicated, because that's not impeachment anymore. It's substantive. And from what the court's found, it would be improper substantive evidence. So you have to probably be careful, or be cautious in how you ask the questions and make sure the witness understands. He may want to tell the whole story, and I'm just not going to let that happen. And if he starts delving into the whole story, he may not be permitted to continue with impeachment because it's getting into substantive evidence, which I am not going to allow from Mr. Harris, because it's not substantive evidence concerning issues in this case.
I just want to be clear, but I think obviously some sort of context is going to be necessary.
I agree with
to
that.
tell the story. Okay.
I agree with that.
Okay.
But did you have an incident on a particular date and time, setting up the time, the state, I mean, there are more leading questions, but I think leading questions, you want to set the scene, and I want to allow you to have. On a certain date and time, did you have contact with Mr. Altheimer, something of that nature? But why did you have contact is something that would get into substantive evidence, because that's not what Mr. Altheimer testified about, and I'm not going to allow that. So it's, and in fact, I should hear from the state about this before I make a ruling, but you may need to ask leading questions to focus on the impeachment, because otherwise the questions could be too broad if you don't ask leading questions, and may get into evidence where the witness is going to say something that the court wouldn't permit, the state's going to have to object, the court will have to tell the jury to not listen to it. I don't want the jury to hear it to begin with. So the court, I will hear from the state, but I'm leaning toward giving the defense broad ability to ask leading questions so it could be narrowed to the impeachment part, because otherwise it's going to be difficult for the defense. I assume this witness is not a lawyer. I don't know this witness, but I assume is he a lawyer?
No.
All right. So the nuances of this, witnesses generally want to try to answer what they think they're answering, but they may not hear it carefully, and so I may grant some leeway on leading questions from the defense, but I should hear from the state before I decide that.
Your Honor, the court rules allow that, and the state has no objection. The court rules allow the judge to allow leading questions in certain circumstances, and here the state has no objection.
I mean, it's really a preliminary setting of the scene, and the defense has to be able to do that, or it's going to make no sense to the jury at all. Just, did he have his headlights on a certain day? Well, that doesn't make any sense. That wouldn't even make any sense to me if I heard that. So you'll get some leeway, but if you want to use leading questions, I'm going to grant leeway on that. Any questions from the defense about the court's ruling concerning Mr. Harris? From the defense? State?
Your Honor, the state has a motion regarding Mr.
Oh, I'm not.
Harris.
Oh, okay, good.
Your Honor, Mr. Harris was convicted in 2002 of altering 17 checks. He pled guilty to 2 counts of theft. One was a felony and one was not. He was again convicted in 2007. In that case, he was charged with felony theft and misdemeanor theft and a false claims charge, and he ultimately pled to the misdemeanor charges, which would be the false claims charge, which is specifically when you make a false claim to an insurance company. It's right here. I'm looking at Evidence Rule 609. These are obviously well outside the 10-year period, but Evidence Rule 609B says that if it's outside the 10-year period, it's inadmissible unless the court determines in the interest of justice that the probative value of the conviction, supported by specific facts and circumstances, substantially outweighs its prejudicial effect. And here they want to bring in a witness, Mr. Harris, for the specific purpose to impeach statements made by Mr. Altheimer. And as impeachment evidence, the question then becomes, well, who's telling the truth? Well, the witness who says...
No, it's not who's telling the truth. It's that nobody's telling the truth. That's why it's impeachment. If we're substantive, then you would be able to say that. So
Okay. Right, but, okay, I understand the distinction, but Mr. Altheimer says A, Mr. Harris is going to come in and say B, and that brings up a credibility issue. And here you have a witness contradicting our witness who has 2 crimes of dishonesty. One in 2007, specifically a crime of dishonesty, and the other in 2002, theft, also specifically a crime of dishonesty as recognized by the case law. So we're making a motion to admit that, or at least to question Mr. Harris about it.
Mr. Gross.
Your Honor, 609B governs admission of this type of evidence, the time limit subsection, and it allows evidence of a conviction under the rule. It says it's not admissible if a period of more than 10 years has elapsed since the date of the conviction. Based on what the state's saying, more than 10 years have elapsed. It also says evidence of a conviction more than 10 years old as calculated herein is not admissible unless the proponent gives to the adverse party sufficient advanced written notice of intent to use such evidence to provide the adverse party with a fair opportunity to contest the use of such evidence. And the state has provided no advance written notice.
So defense objects.
Objects.
State.
No further response.
I should have said this before, and I looked at my notes and I may not have. So with respect to state's motion in limine G5, where the court granted the state's motion to prohibit testimony of Mr. Harris, the court is modifying that ruling based on what I previously said. So I want to make it clear that the motion in limine has been modified so the defense can proceed as we've discussed. With respect to the impeachment by evidence of a crime under ER 609, the defense objects because it wasn't provided prior written notice. The rule requires that because these crimes of dishonesty are over 10 years old, and so for that reason, the defense objections granted. The state will not be permitted to inquire of Mr. Harris concerning his prior crimes of dishonesty. Anything else from the state on Mr. Harris?
Not on Mr. Harris, thank you, Your Honor. Anything else?
I do want to raise one issue, which is that the state made a comment earlier in this case and brought up Mr. Harris themselves and said that Mr. Harris comes with significant baggage, and that indicates to the defense that they may be seeking to admit prior acts of some kind. I don't know if the state was just referring to these convictions or something else, but I'd like to explore that if the state is seeking to introduce other prior acts.
Mr. Tratnik?
Sure, Your Honor. Mr. Harris, who thought the newspaper looked like a gun, formed that opinion while he had a gun in his lap. And Mr. Harris, in May of 2022, was again carrying his firearm when he shot multiple rounds from his handgun at an auto theft suspect near a homeless encampment within earshot of police officers. Mr. Harris's view of this encounter with Mr. Altheimer is relevant in the fact that he had a gun. Mr. Altheimer did not have a gun, but he believed, ooh, that could be a weapon. And then here we go again in May of 2022, and the situation there was he thought somebody had stolen something from him, so he went to a homeless encampment, and he used that same gun to fire at what he believed was a suspect near this homeless encampment.
How does that go toward impeachment, cross-examination of a witness who's called for impeachment purposes?
Because what he's testifying to is his encounter with Mr. Altheimer, which includes that he was armed, Mr. Altheimer was not, and in his opinion, having a newspaper apparently makes it look like you're armed. And I think Mr. Harris's perception of events concerning threats and weapons is relevant.
If the state knows at the times of these incidents, was Mr. Harris exercising his Second Amendment rights, or was he prohibited from doing so by possessing a firearm?
Well, that's questionable, since he has these prior convictions, but there's a difference between exercising your Second Amendment rights by having a weapon and shooting it multiple times at what you believe is a theft suspect. That's not exercising your Second Amendment rights to be shooting into a homeless encampment.
How is that any way relevant to this case?
Because it goes to his perceptions as to what he perceived Mr. Altheimer to be doing when they had this encounter.
How does shooting at a homeless camp go to perceptions as to what happened with Mr. Altheimer?
It seems to me that Mr. Harris feels threatened very easily.
What the state proposes to bring up with respect to Mr. Harris is improper character evidence under ER 404 A and B, so the court is not going to allow that cross-examination of an impeachment witness to get into a significantly other incident of which I don't know anything about, and I don't know why I should, but just I only know what the state has said about it, and even if it were in some way relevant or germane, the ER 403 aspects of this to completely confuse the jury with this type of information on an impeachment witness, the prejudice far outweighs the probative value that the defense is seeking to admit impeachment evidence for. So under 404A and B and under ER 403, any questioning of Mr. Harris about this incident that the state has identified, well, is prohibited, and really it would be beyond the scope as well of the testimony of the impeachment evidence, which is another reason why the court's not going to allow it.
Understood, Your Honor. Thank you.
I probably should have asked the defense about this, if there's anything about this incident, alleged incident with the homeless camp and things, but maybe, if you want to say something, I should give you that chance before I rule, but it's just hearing something like that at first blush, I just can't imagine why I would let that be heard by the jury. Assuming it's all true, and I don't know enough about it to even make a credibility assessment on it, which is not really my role anyway.
I just want to make the comment that this was investigated and he wasn't charged with anything.
That doesn't change the court's perspective or ruling. Defense, anything else about Mr. Harris?
I'm sorry?
Anything else about Mr. Harris?
No, Your Honor.
And state anything else about Mr. Harris?
No, Your Honor.
Is that the only way?
You mentioned,
We also, Your Honor, mentioned Kim Brown, who's the aunt of Mr. Alzheimer,
okay.
and check the notes, I don't know that we needed to address her. I don't know that we need to address her. I don't think there's any objection to her.
I don't know if she was, I don't recall that name on the motions in limine.
Yeah, I just was double checking, so getting that we're ready to reconvene, Your Honor, but I don't recall it either. Can you check? I don't see
Yeah,
it.
I did not make a ruling concerning, a motion in limine concerning this witness.
Right.
It wasn't.
Yeah.
And so, so she would be testifying this afternoon, Your Honor.
Your Honor, the state has a question. Our question is whether she's being brought in as a witness for substantive evidence or for impeachment. The reason we ask is that based on the information from our interview of her, it's largely going to be hearsay regarding statements between her and Mr. Alzheimer following the incident on January 27th. And the rest of it would be simply opinion testimony about how Mr. Alzheimer should have interacted with Sheriff Troyer and the Tacoma police officers. And we don't believe that this opinion testimony should not be permitted.
Well, that's somewhat of the state's offer of proof as to what they anticipate the witness might say. Defense, if you want to respond.
Well, Your Honor, I mean, she's both, but the fact is that she saw Mr. Alzheimer within a very short period of time in this claimed incident, and he was still under the excitement of that incident. He was still extremely agitated, yelling, things like that. And this is from the interview we have from the Attorney General's office. Do you want me to just make that an exhibit so we can move on? I mean, she saw him, he's really upset. She said, she's a newspaper carrier. She says, when I deliver and I see the police behind me and they've followed me before, I just wave my newspaper out of the window of the car and they just let me go. And she goes, why don't you do that? Why didn't you do that? And he says, well, I shouldn't have to do that. So they're talking about this incident, again, within the very short time frame of when it happened. She also, let me just get to her statement really quick, Your Honor. Where's Brown? Back that way. Thanks. Right there, right? Here, if I could just sit while I read the rest of this, Your Honor?
Of course.
Thank you. So she basically saying he called her, he said he had a run-in with the sheriff. He said the sheriff called 911. He said he didn't make any threats. He said he called his mom and told her about it. Early morning hours, she wasn't sure of the exact time, but said it was before 5 a.m. And Alzheimer told her he was delivering papers, talked about someone following him. Said he later learned that the driver was Troyer, and he just said he approached Troyer to ask why he was being followed. And then he said after that a lot of police cars showed up and he had to speak with the cops about it. Asked about her nephew's demeanor, what he called that morning, she said, quote unquote, he was pissed off, end quote. And then she also said he was quote unquote cussing and yelling. And recall, Your Honor, that he also went to my client's house around 4-ish in the morning, and then it's somewhere in that time frame after. She said she asked him if the police pulled guns on him, and he told her that they didn't, which is completely different than what he said here on the stand, and different than what he said in his pleadings. She asked him if the police handcuffed him, and he told her that they didn't. Asked if they discussed the incident since that night, and she said she's talked to him about it, like I described. She's told him he needs to be careful what he says and how he says it. She said she'd seen the video from the officer's body cam. It was in the media. She told Alzheimer he could have held the newspaper out the window to signal to the driver he was delivering papers. She said he told her, and this is a quote, I don't think I should have to do that, end quote. Brown then said she delivers papers in downtown Tacoma. She's been stopped by the police before driving slowly around the streets on her deliveries. She said she'll hold a paper out the window and the police always recognize it as a sign that she's delivering papers, and they drive off without delaying her further. She said she also drives with her flashers lights on when she's delivering. She told all this to her nephew and asked him to think about it. Brown said from what she saw in the video, she's happy with the way the police handled the situation. She told her nephew that after seeing all this ranting and raving, seeing all of his ranting and raving, he should have calmed down to speak with the police.
Dick?
Yes, Your Honor, everything that defense just described from the Attorney General's interview with Ms. Brown is hearsay and it's not relevant to the elements in this case. Much of this goes to Ms. Brown's opinion, again, of how Mr. Altheimer should have interacted with police and Sheriff Troyer. We've already had testimony from his supervisor, Mr. Steiner, that Mr. Steiner, when he is stopped or questioned, he holds a newspaper out. So that would simply be repetition. We do not believe there's any basis to bring this witness in, at least for substantive evidence.
Your Honor, it's an appropriate lay opinion under the rules. It would be based upon her perception. She is a witness, a substantive witness, because she talked to him at that time. I think everything here is relevant, and finally, she was not subject of a motion limiting in this case, so I think that she should be allowed to testify without having this discussion with the court. And there's no legal basis that's been cited to the court to keep her off the stand.
That will be determined based upon objections, but
Right.
this is, the court, with respect to whether she can be called by the defense, the answer is going to be yes. The court's going to grant that. It was not subject to motion in limine, and it can be difficult for a court hearing offers of proof without some background information to say, yes, you can't put the person on or not. And so I've done that a few times in this case. I have some offers of proof, but with this witness, I'm not going to do that. With respect to hearsay, I mean, much of it sounds like hearsay and/or lay opinions, which that shouldn't mean you shouldn't be able to ask the questions, but then if the defense wants to object, or the state wants to object, I can just hear the context of when the questions are being asked, and whether it's hearsay, whether there's an exception to the hearsay rule, whether it's a proper lay opinion as to common delivery methods, whether that's an expert opinion. I'm going to need to, if there's an objection, the objecting party is going to have to, well, the state in this case would have to explain under the evidence rules why that evidence rule should exclude testimony or prohibit testimony. But with respect to calling Ms. Brown, if that's, I'm sorry, I assumed that she was female. Is that incorrect? You said aunt, so,
Yes.
and so the defense is going to be allowed to call her, but rules of evidence are going to apply during the course of that questioning.
Of course, Your Honor. Understood.
Thank you.
I probably should, since it was brought up, but, and it's not, does not mean I'm not going to listen to counsel, but there was some questions about shortly after the incident and his demeanor. I do think that is something that would be, I've allowed demeanor questions about all sorts of witnesses, and Mr. Altheimer is a witness, and if the timing of this is in, it sounds like the timing of this was shortly after newspapers were allegedly thrown on Mr. Troyer, that the demeanor of a witness would be something of proper testimony. Demeanor's somewhat an opinion, somewhat not an opinion evidence, but that, unless the defense or state would have a reason why that, her characterization of his demeanor shortly after the incident should not be admissible, that would likely be admitted, but I'll listen to the state if it comes up.
All right. Thank you, Your Honor. And we're ready.
Do you want to argue the motion to dismiss or wait?
I can do it later, Your Honor, because I still have Wendy Troyer and Josh Harris waiting.
You fine with that?
Yes, the state is fine with that. Sarah, is it possible, since it's 10:30, to take a 5-minute restroom break?
I was actually just going to think of that myself. Yeah, I was just cleaning up my notes here to make sure I'm ready for the jury to come back. So
Okay.
this would be a good time to, so the court will take its morning recess, and please be ready to go by 10:45, 10:45. The court is at recess. defense ready to proceed with the testimony of Mrs. Troyer?
We are, Your Honor.
And is the state?
Yes, Your Honor.
Right, if, go ahead and bring the witness, or the jury in.
That's right. I'm like, let's move this.
If the defense wants, she could be brought in now, though. I mean, she's already started testifying.
Right here, Your Honor.
Sure.
Thank you.
Whatever you prefer. Good morning, you can go ahead and have a seat. And if you want to pour some water, you could as well. Or if you have some, that's fine too. Actually, would you like it? Is that cup leaving? We can afford it later. The jury is returning to the courtroom.
You good? Oh, yeah, should the witness stand, Your Honor?
It's up to the counsel and the witness.
All right, thank you.
Thank you. Everyone may be seated, and to the members of the jury, good morning to you. To the witness, you are still under oath. Do you understand that?
Yes.
Ms. Brown?
Thank you, Your Honor. And good morning, Mrs. Troyer. You go by Mrs. Troyer?
Yes.
Okay. We left off yesterday talking about your home and some protests there, and a family member that wasn't visiting. Do you recall that? Or with the children, not visiting with children, I should
Right.
say.
Yes, correct.
And who is that, and what grandchildren are involved?
My daughters,
That's the relevance.
Sustained.
Did you have that house before you married Sheriff Troyer?
yes,
And so how long have you had the house?
since it was built in '85.
And can you describe the neighborhood for the jury in terms of, let's start with, are these windy blocks, are these straight blocks? I mean, what's the neighborhood like?
Yeah, there many hills. Most of the driveways are on our side of the street are, uphill. 2 or 3 cul-de-sacs up Vista View Drive.
And do you have a view of your neighbors across the street from your house?
Yes,
And where's your bedroom in your house?
on our top floor is our bedroom.
And is your house faces Vista View? Would the water be straight ahead?
Yes,
And are the people that are across the street, are they lower than your property in terms of being on a hill?
yes.
But before I get to the matters involving Mr. Altheimer, I wanted to ask you just a little bit of background. It sounds like you and Ed Troyer, at least more recently, have had really different schedules work-wise. Is that right?
For quite a while.
Okay. Can you tell us about that, please? First, where do you work?
I work at a private school in University Place.
And what do you do there?
I'm the transportation supervisor. I run our transportation department.
And when did you start doing that?
11 years ago.
What time do you get up what time do you get up in the morning for your job?
My alarm usually goes off at 3:30.
Okay. And what time do you leave the house?
Between 4:15, 4:30.
And what about your husband and his work schedule?
It varies. Varies.
Can you give us some examples?
Oh, sometimes he's out, gets called out as the PIO. He got called out quite often. Usually I'm asleep, or not, I shouldn't say usually, but most nights I'm asleep before he gets home.
Do you get much of a chance to see each other?
Here and there. Weekends.
Okay. And so you talked about when you leave the house, when do you come back home from your job at the end of your day?
At the end of my day, I work a split, so I come back around 10:30
Mhm.
in the morning, and then I go back at 2, and then I'm usually home by 5:36.
Can you tell the jury what, during the time that you've been married, what roles your husband has played at the Pierce County Sheriff's before he was actually elected sheriff?
When I first met him, he was in patrol, he was a sheriff's deputy. And then he he also was with Crime Stoppers and a detective, and then PIO, Public Information Officer.
And in any given month, when he was PIO, how many times do you think he'd be called out?
In a month? I would say anywhere from 3 to 10.
Okay. How about as sheriff? Is it a different schedule in terms of unexpected call-outs?
It is a little different.
And how's that different?
He's not, he works longer hours, but he's not called out as often. He gets called a lot, but
Gets what?
called a lot on the phone, but he doesn't actually get called out as often.
And does he also attend with you events outside of the sheriff's department?
Yes.
And can you tell the jury about those types of events?
Oh, we volunteer with many nonprofits.
Back to relevance.
Overruled, some leeway.
Thank you. You can go ahead.
A lot of nonprofits with Toys for Tots and Foster Parent Association, the Polar Plunge for Special Olympics. A lot of stuff.
A lot of stuff.
Mhm.
How many nights a week are you involved in activities like that?
It's seasonal,
How about the
Seasonal.
season, the holiday season?
almost daily.
And what are you involved in almost daily during the holiday season?
Toy distributions and collecting toys and running fundraisers to receive toys.
Have you, let me strike that. I want to ask you about this case and ask you if you can remember back in January of '21, your husband coming home from an incident. And before Mr. Alzheimer threw a newspaper at your house, so I'll give you the time frame for the day, early morning.
I remember waking up when he came home.
Okay.
I was asleep when he left, but I was awake, or he woke me up when he came home, because I hear him and he was talking on the phone, and so.
What time was that approximately?
I can't say for sure, but I know it was before my alarm went off.
And we talked before your
3:30.
alarm goes off around 3:30 in the morning?
Yes.
Yes, okay. And what was his demeanor like when he woke you up?
He was upset.
And was he, how does he act when he's upset?
Kind of shuts down, and I mean he talked about it, about what happened, and but he's not. I don't know. We just talked about it.
Did he seem to be still under kind of the excitement of that event or the influence of something that happened to him that upset him?
Yes.
What did he say to you?
He just said that he.
I'm going to object if this is going to get into statements about the incident. Those are self-serving hearsay. They're not party admissions.
Ernest, excited utterance and res gestae. It's Rule 803, Your Honor.
The court's looking at evidence rule 801A2, admissions by party opponent. The objection's overruled based upon that evidence rule.
Thank you, Your Honor.
So if you want to ask a question again, you could, but
I would like to.
the witness can be allowed to answer if she's able.
Thank you. So we're just talking about that he woke you up before your alarm went off at 3:30, and he was upset. You talked about his demeanor, and I asked you about whether he seemed to be still under the excitement of whatever that event was, or the stimulus from that event. And what did he say to you?
I learned most of it, he was on the phone, and so I could hear his conversation. And so I, received a lot of information through that. And then once he got off the phone, he told me that he saw headlights, and then the headlights shut off at our neighbors. And that he went to look to see who it was, and then the rest of the night that happened about him stopping and calling the back line of the dispatchers.
Did he tell you what he said to the dispatchers?
No.
Did he indicate anything about whether he was threatened by this individual?
Sure. To the repeated leading questions.
Sustained. Well, sustained to this leading question.
Okay, thank you, Your Honor. Can you tell us whether or not he said anything about what Mr. Alzheimer said to him?
He just said that he,
That's double hearsay.
This, yeah, maybe, perhaps some clarification as to what the question, the specific question that's being asked of her. So I don't understand, if you're seeking to have what her husband said about what Mr. Alzheimer said, the objection is sustained.
All right.
If it's about what her husband said without that hearsay, it's overruled. So I
All
may
right.
need clarification to your question.
Thank you, Your Honor. Let me ask you this way. Your husband said something happened, and he was on the phone about it. Can you tell the jury in a nutshell what he said happened and why he was calling? Why was he calling a backline from what he
Object
told
to the
you?
narrative.
It's really more of a compound question, so you overruled.
Thank you, Your Honor.
Well, I'm sorry. Object that it calls for a narrative is what I meant to say.
Overruled.
Thank you.
he just said that he saw a car go up in our neighbor's driveway, and the lights were off, and the car was in our driveway, and he followed it,
Mm-hmm.
and the driver, he found the car, and the driver got out of the car and threatened him and confronted him.
And someone caught, what?
Confronted him.
So you said that your husband told you that Mr. Alzheimer threatened him and confronted him. Is that
Yes.
right?
That he got out of his car.
Your objection, that's not a question. She is repeating the testimony.
I think the last statement she made was, "Is that right?" So overruled.
You just thank you, Your Honor. You just testified that your husband told you at that time before 3:30 in the morning that Mr. Alzheimer threatened him and confronted him. Is that right?
Yes.
What happened next then after he was on the phone talking about this and talking to you about it?
By that time, it was time for me to get ready for work, and I was up getting ready for work, and I heard, sounded like somebody talking, and at that point, he was laying down in bed.
When you say he, you mean?
My husband, yes. And I heard a voice, a noise, and so I walked to our window and peeked through the levelers and saw not silver, but kind of a gold colored
Uh-huh.
car. And I heard yelling, and there was a man standing outside of his car, and he was just yelling.
Was he actually in your driveway or in the street?
His car was in the street, but he was up closer in our driveway.
And what went through your mind when you saw and heard these things?
I just alerted my husband, and he got up and looked out, and the car drove away.
I'm sorry, the last part you said?
My husband looked out the window, and then the car drove away. The man got back in his car and drove away.
Okay. Could you make out what he was yelling, any words?
I couldn't. He was just screaming loud.
And did anything else happen with this particular person that you saw?
That night, no, when I was going to work and backing down the driveway, I saw a newspaper. And so I called my husband and
Go
told
ahead.
him there was a newspaper in the driveway. And he was aware.
Okay. Now, you didn't take the newspaper, I take it?
No.
Did you used to?
Yes.
How long ago?
Oh, 3, 4 years prior.
Okay. So that wasn't your newspaper, you weren't expecting to
No.
have that? Then did your husband go out and look at the newspaper?
No,
Did you pick up the newspaper, either of you?
I did not right away. It was when I came home.
And tell us about that, please.
It was the morning of, and 10:30 in the morning, and the newspaper was still in the driveway.
Did you save it?
Not that one.
'Cause there was another one, is that right? Can you tell us about that?
I believe my husband had that one, the day one, because he had wanted to give it to an office.
Non-responsive.
Sustain. Sustain.
Thank you, Your Honor. There was another time a newspaper ended up at your house, it sounds like.
Yes,
Was it in the driveway again or somewhere else?
it was the very next day. It was in our driveway.
And I'm just going to hold up, this is an exhibit that's been admitted, Exhibit G. Actually, if I could approach the witness, Your Honor.
Granted.
Does this look similar to the type of newspaper?
I don't think it's G, though.
I can't read these. I think it's G or C.
I think it's C.
Oh, it is C.
Exhibit C, thank you.
Showing Exhibit C.
That's the newspaper.
And was that the one then that was in the drive at your house?
The second day, yes.
Second day, okay. Do you know who left that newspaper the second day?
The newspaper was just there, no.
When the person was in the car at your house, what time was that?
When I heard him yelling out
Yes.
the window?
Right.
Oh, it had to be while I was getting ready for work, so between 3:30 and 4.
And what went through your mind when you heard this person yelling?
I was alarmed, that's why I woke my husband up.
Overruled.
Thank you. You can go ahead and
That's
say
why I
that.
woke my husband up, or alerted my husband that,
Right.
because I heard yelling, he didn't acknowledge it, and I was closest to the window, so when I heard it, I looked out the window and I said, Ed, I said, there's somebody down in our driveway. And he stood up and looked out the window.
And I had asked you what went through your mind at that time, and there was an objection, so I think your answer was cut off. What was going through your mind at that time when you heard this yelling outside your window, you couldn't make out what they were saying, et cetera?
Objection has
person.
been asked and answered.
Overruled.
I couldn't even hear the answer because of,
Overruled.
thank you.
I was scared, I was scared.
Did you feel threatened?
Oh, yes.
Thank you, that's all I have.
May I?
Cross-examination?
None, Your Honor, thank you.
Thank you. You may step down. Is this witness excused?
Yes, may she remain now, Your Honor? She'd like to,
Okay, so is she excused from the defense?
she is, Your Honor.
Is she excused from the state?
Yes, Your Honor.
You may step down, and yes.
Thank you.
Thank you.
We call Josh Harris.
Raise your right hand to be sworn.
Oh,
Do you
that
swear
was
or-
bound to happen.
Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Have a seat, please. State your name and spell your last name.
Joshua C. Harris, Harris.
Ms. Bremner.
Thank you, Your Honor. Good morning.
Morning.
Can you tell the jury, where do you live? What part of town?
North end of Tacoma,
And what's in cross street for
Orchard and North 35th Street.
I'm going to ask you some specific questions about this particular case. Do you recall having any contact with a Mr. Cedric Altheimer at any time? Somebody you came to know was Mr. Altheimer.
I did, yes.
Can you describe the circumstances, briefly with respect to how you came into contact with him, where you were, where he was, and who, if anyone, you were with?
My wife and I came home from a Tacoma Fire Department charity ball. It was about 2 o'clock in the morning on a February in 2020, I believe. And as we turned off of Orchard onto our street where we lived at the time, there was a vehicle parked in my neighbor's driveway. They're 80 and 90 years old. I had a work truck of my own parked in their third driveway and saw a vehicle parked next to it with its lights off, and I pulled over to the side of the road to see what was going on with the car next to my truck.
And what happened next once you did that?
We sat for about 4 or 5 minutes, and the car was just sitting there. After about 4 or 5 minutes, the reverse lights came on. It pulled out of the driveway and drove down North 35th, westbound with its lights off and kind of swerving. We followed it for about 3 or 4 blocks into another part of the neighborhood, and it pulled into a driveway with its lights off.
Okay. And at that point, what happened?
My wife was tired, and she asked me to take her home, so we went home. I dropped her off, and I told her I'm going to go back, make sure that car stayed in that it was a neighbor. We kind of had figured maybe it was a neighbor that was drunk and went to the wrong house. I went back to the location of the house where I saw it parked last, and it was gone. And on my way back home, saw it in another driveway.
When you saw it in another driveway, what did you do?
I was about half a block away, so I sat there and watched to see what they were doing. I didn't know if they were casing houses out or what was going on. It sat in that driveway for about another 4 or 5 minutes. At this point, it backed up and turned its lights on, pulled into another driveway, sat there, pulled back out, and at this point I was tired, so I pulled up next to the vehicle and rolled my passenger window down and just asked him, hey, what's going on, what are you doing? The driver yelled at me, mind your own effing business, da-da-da-da-da.
Let me stop you there for a minute. The driver said, mind your own effing business, and what, da-da-da-da, do you remember what that was additionally to mind your own effing business?
He kind of went into a tirade of, what are you bothering me for, blankety blank. I said, hey, you were in my 80, 90-year-old neighbor's driveway at 2 o'clock in the morning. You are in my business. You're parked next to my work truck that's been broken into. I'm just asking you what you're doing in the neighborhood. You're driving in all these parking lots and swerving around. I'm asking you what you're doing.
And his response?
He returned with, you need to mind your own effing business. I was looking down across him because there was another person in the vehicle. I noticed a female in the vehicle. He just kept swearing and, telling me to mind my own business, this and that. I said, hey, look, if you don't want to tell me who you are, I'll just call the police and find out who you are. He pulled forward at that point ahead of me and off to the other side of the road and onto the curb and got out of the car and said, what is it, because I'm black? And as he came around the corner, he had his hand up underneath his sweatshirt like he had a gun. And I told him, dude, this is not the way you want to handle this. You get your hand out from under your sweatshirt. I'm just asking you what you're doing in the neighborhood. And normally, our newspaper delivery that I've seen deliver in the neighborhood delivered at 5:30 in the morning. So,
Objection to the narrative and well outside the scope of the motion in limine.
Sustained.
Your Honor, with the court's permission, I'd like him just to show what he saw. If he could stand up and show what he saw with the newspaper, what Mr. Altheimer was doing with the newspaper. I'm just asking him just to stand up and show what he was trying to show by sitting. I just want him to stand.
Not quite sure I understand what you're,
Oh, I'm sorry, Erna, I just wanted him to demonstrate what he saw. He talked about Mr. Altimer having a newspaper under his sweatshirt, and then,
oh, I understand.
that's it. I mean, I just
Okay.
asked permission.
I defer to the court, Your Honor.
Yeah, granted.
Thank you,
Now that
Ernie.
I understand what you're saying.
Thank you. Thank you, Erna. If you could step down, sir, and show the jury, when you were talking about him having a sweatshirt and a newspaper and then using it like it was a gun, can you show us?
He just came around the side of the car with his hand underneath his sweatshirt like this and turned to me and said, "What, is it because I'm black?" And I said, "No." And I again explained to him why I was asking what he was doing because of his behavior.
How did you learn it was a newspaper that he had underneath there?
After we had a conversation, I kept asking him, "Why don't you pull your hand out, man? Just let me know what you're doing. Tell me what you're doing." And he kept going back, "You need to mind your own business." I don't remember exactly what the specific words were used at that point. And then he reached down and kind of pulled the newspaper out. And as he pulled it out, he threw it up on the neighbor's porch. And then he told me, "I'm delivering the newspaper, you blankety blank. Why don't you mind your own business?" And da-da-da-da-da. And I said to him, "You could have told me that 15 minutes ago, and I would have been at home in bed. You could have got yourself shot running around acting stupid like this." And that was the end of that conversation, and I drove off and went home.
Was that the last time you had contact with him?
No.
Can you tell the jury about the next time you had contact with him?
So that happened on Sunday morning at 2 a.m. Monday morning at about 4:30 a.m. My wife heard a panic knock at the door, woke me up. I came to the door, opened the door, and as I opened the door, he was walking off my porch, threw a rolled up newspaper back at me, told me to F off and mind my own business, and as he jumped in the car, he told me to quit harassing him.
Did he leave any kind of note with the paper?
I remember there was something like a small note that was in the rubber band. I don't even remember what it said. I threw the newspaper away.
He's indicated at least that was a friendly conversation. He was just asking you to subscribe to the Tribune. Did that happen?
No, not the first time. There was a second time.
So, what went through your mind during this incident?
After that, my wife and I were pretty upset, and so we had written to the TNT to tell them about the incident, and we were pretty provoked that, this went over the top, and so we were looking at what we needed to do, one, because of his aggressive behavior, and two, because of the fact that he came to our house that time in the morning. My wife and I contacted the TNT.
Outside the scope of the motion and eliminate.
Sustained.
Let me ask you this. How did you now know that person that you had contact with in those two occasions that you just talked about was Cedric Altimer. How do you know that it was Cedric Altimer in both incidents?
We had looked up, I called the TNT to find out who delivered, and they couldn't give me the information. And I didn't know his full name until the second time that he came to our house, when he told me his name.
Okay. And did you subscribe at that time to the Tribune?
No, we do not subscribe to the Tribune.
And had you for any period of time before that?
No.
Do you now?
No.
Did you feel threatened at all?
The first time, his demeanor, yes.
Objection outside the scope of the motion and eliminate.
Sustained.
That's all I have. Thank you.
I'll just strike that last response.
Granted.
Good morning, Mr. Harris. I'm just going to stay here if that's okay. Can you hear me okay?
Yes.
All righty.
Cross-examination.
Now, Mr. Harris, you know Mr. Troyer because you serve on a board together, correct?
I did, yes.
And the incident that we're talking about, and you talked to Mr. Troyer sometime after this incident, correct?
Yes.
Okay, and Mr. Troyer asked you to give a statement about the incident, is that correct?
Objection hearsay. 801 is not
Sustained.
admission.
No, sustained.
Did Mr. Troyer ask you to give a statement about this incident?
Same objection, it's outside the
It's a
scope.
party admission.
Sustained.
statement by Mr. Troyer to Mr. Harris. It's a party
Please, Madam Mayor.
admission.
It's not an admission, Your Honor, and it's 8:01, and it's beyond the scope.
Overruled. Oh,
It's beyond the scope.
sustained, just to be on the scope.
Thank you.
Did you give a statement about what you just testified to?
Yes, I've given a statement to the News Tribune, and I was also contacted by the AG's office by an investigator.
Okay, and do you remember the investigator's name? Was it Brad Graham?
Uh,
Was it a male or a
Yeah,
female?
a male, I believe it was, Graham was his last name, yes.
Okay, and Mr. Graham asked you about a conversation that you had with Mr. Troyer, correct?
I believe so. I've talked to two different people, and that was quite some time ago, but I'm sure we had a conversation.
And you relayed to our investigator what Mr. Troyer told you about this incident, correct?
Objection, it's outside the scope of direct, Your Honor.
Sustained.
Now, the incident you're talking about occurred in February of 2020, correct?
Correct.
Okay, that was a year before the incident of January of 2021, correct?
Correct.
And it was in February, and in February it is cold, correct?
Correct.
So on this cold February day, Mr. Altheimer had a newspaper underneath his sweatshirt. Is that your testimony?
Yes.
And he didn't have a gun, did he?
No, he did not.
Okay, but you had a gun, didn't you?
Yes, I did.
You had a gun in your lap during this encounter with a man that you followed who was pulling in and out of driveways, correct?
Correct.
Okay. And on some occasions, when you were following Mr. Altheimer, sometimes his headlights were on and sometimes his headlights were off, correct?
At a couple times, he pulled pulling out of one of the homes, yes, he turned his lights on. And that's when I confronted him.
That's all, thank you, Your Honor.
Redirect.
Thank you, Your Honor. Do you have a Second Amendment right to have a gun?
Yes.
Thank you, that's all I have.
No redirect, Your Honor.
Thank you. You may step down. Is this witness excused, defense
Yes, thank you.
and state?
We'd like a subject to recall.
All right.
Thank you,
You are
Mr.
subject to
Harris.
recall.
I think now would be a time to take up the motion, Your Honor, that we discussed earlier.
All right. Any objection from the state?
No objection.
Leslie, are the lunches there? Oh. Yeah, I just checking to make sure your lunches are here, and they are.
They are. I
So
should
I'm not
ask.
going to make you wait till noon to eat them. So if you're going to, at this time, the jury is excused, no talking about the case with anyone, no research, and you certainly can start eating your lunch, or if you want to wait till noon, that's up to you as well.
Yeah. That's the appropriate.
The jury has left the courtroom, and thank you. Everyone may be seated. Just making some notes here real quick. And defense, motion to dismiss.
Yeah, thank you, Your Honor. If I could just stand up here so I can see my phone a little bit higher.
Granted.
Thank you. And we had reserved argument on this following the state's resting after their case in chief. But now we move to dismiss under State versus Green for sufficiency of the evidence. State v. Debris, 149 Washington 2nd, 842, 2003. State versus Salina, et cetera, which cases all say the same thing, of course, which the court knows, is that the evidence is sufficient if, when viewed in the light most favorable to the state, any reasonable trier of fact could find guilt beyond a reasonable doubt. When a criminal defendant challenges the sufficiency of the evidence, the defendant admits the truth of the state's evidence, and all reasonable inferences therefrom are drawn in favor of the state. The state has the burden showing in this case, I don't know if the court has before it the RCWs or I can also provide the court the criminal complaint with the 2 counts. But this is, as you.
Both in front of you.
I figured you did, Your Honor. Thank you. The statutes, you've got knowingly, which of course is not something we could really move on, but I think it bears discussion here in this context. As I look at this in terms of legal causation and proximate cause, even at this juncture, but for causation, and we look at the WIPICs on definition of cause, it's got one on homicide, and then a general causation, WPIC, with the citations and notes. But this is a unique case, and you're well aware what the facts are so far. Of course, the state has prominent witnesses saying that there was a call to an inside line. In the media, of course, it was stated generally as a call to 911, which it wasn't, which is what the statute, I think, contemplates. You call for emergency services, i.e. 911, and if you knowingly give false information to them, either to a public servant or in eliciting an emergency response, you can be guilty under the statute. But in this case, you have a very unique circumstance, Your Honor, and that is the defendant's the sheriff. So he has access to an inside line. It's one that's used, as you'll recall, for kind of mundane things, who's going to lunch, or I'm using examples, but everyone said day-to-day kinds of things. It is not an emergency line. So the question is, in terms of his mens rea, his intent, knowingly, but also proximate cause, when he called in and said, I need 1 to 2 units, is that even enough at this stage under Green to establish a prima facie case of calling for what would be foreseeably emergent services responding? I don't think so, because he's basically said over and over in the case, and we've asked questions of witnesses about this, that he's dealing with his own unique circumstance. It'd be like the chief of police in Seattle or chief in New York or the sheriff in Pierce County. They've got an internal line, and he is the sheriff. So he doesn't expect, from his vantage point, that there's going to be 40 cars that don't come after all. He's expecting that people follow what he asks, which is, I got a guy here, trying to calm him down. You'll hear from my client on the stand. But importantly, he's basically saying, I just need 1 or 2 units. And he's just calling it just an inside line. So how is it foreseeable that something entirely different happened? Really a world away from what he requested. You had a couple of the folks that were dealing with communications dispatch, and of course we've heard from him, Mr. Shadle, talking about, well, he did say 1 to 2 cars, but I didn't put it out there. And then, of course, he was counseled for that and disciplined because he didn't put it out there. Basically it was put out in a way that he interpreted and put out, that he put it as an emergency, a tone call, etc. I'd submit to the court that that's a superseding, intervening cause, because what would have been set in motion by my client isn't what happened at the end of the day. And how can he be charged criminally for something he didn't intend to do and he didn't do? From his vantage point, I think it's important to look at his vantage point, not in general. As the sheriff, if he calls and says on an inside line, can you send me a couple of units? And they decide to veer off in a completely different direction and put us into this courtroom, I think the case should be dismissed now. The fact of the matter is that both of those dispatchers were counseled or disciplined or whatever, and I didn't want to pick on them too much, but the fact is they made some mistakes that their independent acts superseded anything that the sheriff did. Because all things considered, at the end of the day, when he made his call, what did he expect? 1 or 2 units. What was foreseeable? 1 or 2 units. That's it. Couldn't be a crime because he didn't knowingly cause this emergency through a false statement. I think that, it's important that we look at the whole issue of like a superseding cause on this because, it actually kind of woke me up at 3:30 this morning when I was listening to the witness. I was just thinking about this on the motion to dismiss. How can you convict somebody for something they never intended? in terms of this statute that says it's foreseeable, what you did, it was foreseeable to you, Sheriff Troyer, that this emergency response would occur. I just don't know how you get there. Now, I'll probably hear from the state on the public servant service prong, that he made a statement to a public servant, but the fact of the matter is, there's no evidence here that he made a false statement. I submit to you that basically, even if you say you believe what Officer Lawless, or now Detective Lawless, has to say, what we keep ignoring, at least in general, is that he said, that Troyer said the guy wanted to fight. He did say that to him. And the evidence also shows that there was a conversation with Officer Hobbs present, Officer Lawless, and my client. And the best evidence, which we've seen on the body cam in the exhibit, albeit its conditions relatively poor in terms of the sound, is that there's a statement, generally, that Sheriff Troyer said he was threatened. How can this case go to a jury on this, on these kinds of facts? I know these cases are, there's rarely a green motion granted, but I wanted to make my record on this because I think this is an exceptional case. A lot of times we know they're kind of perfunctory, or you have to do it to keep your record and everything else. But I think this case is different. On these facts, I don't know that it should go to a jury, and I'd ask the court to consider that. There's so many cases after Green, talk about sufficiency of the evidence, and oftentimes it's just a credibility call, etc. But the great weight of the evidence and the best evidence supports the defense, and I'd submit to the court that they cannot make it on proximate cause, but for causation, because it's superseded by the acts of others. And they were well-intentioned, but they weren't the expected acts that were foreseeable from my client's vantage point. Thank you.
Thank you. And I certainly we're hearing from the state, and but so I think I know the answer from both sides, but in researching these two statutes, the false reporting statute and the making a false or misleading statement to a public servant, there is almost no appellate case law on this. And I looked extensively because that would help the court regardless of the motion. And maybe it's not surprising because it's a limited court kind of case. If there was an appeal, it would go to Superior Court, so maybe it never gets reported in appellate. But if you have any of that, I mean, I don't think it's going to, whether there's case law or not, I listen to both sides and make rulings like I have in this case, but I maybe should have said this before, but I just couldn't find anything. And so if you have it, I'd love to see it, because I certainly could have missed it. But if not, I recognize that there's reasons why there may not be appellate cases. I know these types of charges it is not infrequent that as a district court judge, I have seen charges like this of gross misdemeanors, but that doesn't mean they get appellate review. So if you have anything, please let me know. If not, I understand. Ms. Bummer, I don't know if there's anything you want to say.
No, nothing further, Your Honor. Given that we're going to have the weekend, I think, before we close, I'll keep looking. And I know the court will too. Thank you.
And state's response to the motion to dismiss.
And can I just ask for a point of clarification, Ms. Bremmer? Are you only talking about the false reporting?
I'm sorry.
Is your motion limited to the false reporting RCW or to both RCWs? The making a false and misleading statement?
Your Honor,
I just
I
want to know
generally,
if I need to address both.
Well, if I could intervene, my understanding of the argument was that it goes to both, and the motion to dismiss both charges and dismiss the case. And I mean, that's my understanding of the defense motion. Is that incorrect?
absolutely correct, Your Honor.
All
Thank
right.
you.
So
wanted to be
hopefully that
clear
answers
on
the state's question.
So first of all, regarding false reporting, I will note that this is a relatively new statute. It is from 2020, and that's another reason that there isn't really any case law on this yet. But what the elements of the crime are, according to the RCW, for false reporting is as follows. But first of all, as you know, at this juncture, the court has to view all of the evidence in the light most favorable to the state, and also to draw all reasonable inferences from the evidence. False reporting, the elements of that are as follows. That on or about January 27, 2021, the defendant initiated or circulated a false report or warning of an alleged occurrence or impending occurrence. Now, there's been a lot of discussion in this case about the fact that Sheriff Troyer did not physically dial the numbers 911. but he did call into an emergency center and get directly to the dispatcher. But more importantly, that's not required for this charge. All that's required is that on the date in question, the defendant initiated or circulated a false report or warning of an alleged occurrence. Doesn't matter who he reported it to. And if you look at the rest of the statute, the parts that don't apply to this case, it also includes, for instance, occurrence or impending occurrence, knowing that such false report is likely to cause evacuation of a building, place of assembly, transportation facility, public inconvenience, or alarm. There doesn't have to be a call. You can send an email, you can call a school and say there's a bomb in there, you can post something on social media, indicating some sort of threat that causes an emergency response. So whether or not he actually dialed those three numbers is completely irrelevant here. What's relevant here is, did he initiate or circulate a false report or warning of an alleged occurrence, and that the defendant knew that the information reported, conveyed, or circulated was false, right? So the question is, when he said, someone threatened to kill me 4 times, is that false information? And it struck me in opening statement that counsel told the jury that the only evidence of that either way is the testimony of Officer Lawless. And that is simply false. What you have here is, apparently Mr. Altheimer's testimony doesn't matter. Mr. Altheimer testified, I never threatened to kill the defendant. I never threatened him in any way. And then if he testifies, well, at this juncture, the person that Sheriff Troyer claimed had threatened to kill him said, I never threatened to kill him. So whether or not that's a false statement is a question for the jury to decide based on the evidence and based on their view of the credibility of the witnesses. That the defendant knew that the false report was likely to cause an emergency response. And again, there's been a lot of discussion here about the number of cars, but the statute defines emergency response. It's defined in 9A.84040, subsection 5. And the statute defines an emergency response as any action to protect life, health, or property by a peace officer or law enforcement agency, here, Tacoma Police Department, of the United States, the state, or a political subdivision of the state. An emergency isn't a million cars going to the scene. An emergency response under the statute is any action taken by a law enforcement agency to protect life. And that's what happened here. So even as soon as he even asked for 1 or 2 cars, he is asking the dispatcher to send 1 or 2 cars. That in and of itself is any action, 1 or 2 cars, any action to protect life by a law enforcement agency. So by their very own argument, that's already met. But as you know, a lot more happened here. And the reason a lot more happened here is that the dispatchers, prior to hearing 1 or 2 cars, the first thing Sheriff Troyer tells them is, I caught somebody in my driveway, he threatened to kill me, he's here right now, and I have him blocked in. And based on that information, the first thing that they hear, it gets toned out, and every dispatcher, 7 dispatchers and 3 relief dispatchers, see that statement by Sheriff Troyer, and they start sending all of their units, and that's how you get to over 40 units. There was also testimony by Mr. Shadle that the request for 1 or 2 cars did not impact him, and also by Ms. Heiberg. What impacted them was an officer was calling saying that someone had threatened his life, and that automatically triggers an officer needs help call, which is the highest priority. It's the priority 0 call. And of course, that the acts occurred in Fort County, Washington, and we've had plenty of testimony to that. So at this point, it's a question for the jury. And then the second charge is making a false or misleading statement to a public servant that on the date in question, the defendant made a false or misleading statement to a public servant. Again, it's for the jury to determine if Mr. Altheimer's testimony that he never threatened to kill Sheriff Troyer was true or not. And if they determine that it's true, then Sheriff Troyer's statement to the public servant that Mr. Altheimer threatened to kill him proves element one. The public servant, that's any person who's a government employee or performing a governmental function. Here, that's Mr. Shadle. He's a dispatcher for South Sound 911. He explained that that agency provides dispatching services for Pierce County law enforcement agencies. He testified that those law enforcement agencies are government agencies. So when Mr. Shadle, as a dispatcher for South Sound 911, dispatches the vehicles, he's performing a government function, which in this case is the function of dispatching the police. The third, making a false or misleading statement, is that the defendant knew that the statement was material and that he knew that it was false or misleading. Now, in terms of it being false or misleading, we've already addressed that, so I'm not going to address that again. But in terms of knowing that the statement was material, materiality is defined as follows. A material statement is a written or oral statement reasonably likely to be relied on by a public servant, in this case Mr. Shadle, in the discharge of his or her official powers or duties. In this case, excuse me, I'm getting sore throat, I'm losing my voice here. In this case, dispatching the units. And whether or not the defendant knew that that was a material statement, I think that's a question for the jury to decide, and there certainly is a lot of evidence of that here. The defendant in this case has been in law enforcement for decades. He knows how the dispatching and 911 system works, and quite frankly, I think it's pretty obvious that when an officer calls and says, "My life has been threatened," that the dispatcher is going to rely on that. That it's reasonably likely that a dispatcher is going to rely on that. And Mr. Shadle said he did rely on that. And notably, 7 other dispatchers and 3 relief dispatchers also relied on that. So I think there's plenty of evidence for the jury to take the reasonable inferences in the light most favorable to the state at this juncture, that the statement was material and that he knew it was material. And not only did the dispatchers, not only were they reasonably likely to rely on this, they actually relied on this. And then the fourth element, again, is simply the Pierce County, Washington element. So the state has met its burden at this juncture. Now a question for the jury.
Defense response.
Thank you, Your Honor. Where's the evidence that he knew it was material? It's not there, and there wasn't evidence about 7 other dispatchers, Your Honor.
What makes this case unique, as I talked about before, Your Honor, are a number of things, but including in response to the state. The state's trying to say it was foreseeable that this would be the response, and talks about an emergency response being defined as a police response. But what about it when it's the police that makes the request? What if it's the chief, the sheriff? Doesn't that put it in a whole different category? Because he's going to know, because he asks his employees, could you send a couple of cars? That's totally different. I mean, this statute exists for a lot of reasons, but I submit to the court, not for this case, that he makes a call on an inside line saying, this is what I want. So what was just cited to you is that because he got a police response, he's guilty, he's the sheriff. Then he's probably guilty every day, in terms of telling people what to do, where they need to go, and everything else. Guilty as charged. That doesn't make any sense. I mean, it would be an absurd result. I think that given that we're going to have some more time this weekend, I'd like to look at this some more, Your Honor, because I think these are really compelling arguments for him. He's in a unique situation. He is the sheriff of this county. And when he asked for help from his employees, he got charged with a crime by the Attorney General, not the Pierce County prosecutor, but by Bob Ferguson and his people. And then
information is charged by these two lawyers and signed by them, it doesn't fit this case. And so I would like to submit some more to the court if I can find anything. I know if the court hasn't found it, then I clearly won't, but I'm willing to try. And that's how I'd like to leave it now, but we'd move to dismiss for want of evidence under State v. Green.
Is the defense request that the court delay ruling and give an opportunity
Yes.
to potentially have additional argument, or do you want the court to rule today?
I would like to delay for additional argument and briefing. I'll be working anyway.
I mean, with respect, so thank you for, anything else about the
No,
argument?
thank you, Your Honor.
State,
Your Honor, just two responses. The dispatchers are not the employees of Sheriff Troyer. And secondly, there's nothing unique or novel about asking a jury to, based on direct and circumstantial evidence, determine the knowledge of a defendant. Knowledge and intent and those mens rea are elements in almost every crime, because as the court knows, there are very few strict liability crimes. And the state is asking the court to rule today, because the state's asking the court to rule today.
I'm not sure I understood the last part you said. So you're not claiming that either statute's a strict liability crime, correct? Because they both have mens rea.
No, not at all. I'm saying knowledge is an element here.
Right, okay.
And that asking a jury to use direct and circumstantial evidence to try to determine a mens rea, in this case, knowledge of a defendant, there's nothing novel or unique about that, because there are so few strict liability crimes.
Yeah, I just wanted to clarify, because that would be a completely different analysis if this were a strict liability crime, and both crimes have the mens rea of knowledge at least.
Yes, of
I may have
course.
misheard what you said, but
I
it just
believe
surprised me
you
when I
might
heard,
have.
when I
No,
heard strict
I-
liability, that surprised me, because that's a completely different, so.
All
my
I was
mi-
saying is mens reas are almost always an element of the crime, including this one. I'm losing my voice a little.
Right, so with respect to this motion, the defense has asked for additional time to see if they can find additional legal research to support their position. We have the time in this case. We're going to be back here Monday anyway, and as both counsel are probably very aware with how I proceed, if you have more research and we have time to get it, I'd rather have the research than not have it. And so the court's going to grant the defense motion to not rule on its motion to dismiss today. I'll wait to see if the parties can come up with more legal research, and then we'll address it Monday morning. Because I don't think there's prejudice to either side by waiting on my decision on this. I suppose that may mean evidence that we take this afternoon would be prejudicing the parties, because if I granted the motion, we wouldn't need to take it, but I want to hear more legal research if you have it. Now, I do want to say, you do not have to provide me extensive briefing about State versus Green and the standards with respect to this motion. I can assure you both that I'm very aware of the legal standards that the court is supposed to use for addressing this motion. If you want to present it, I'm going to read it, but that is something I wouldn't want to have you take too much time on. I know the case law, but if you want to give it to me, I'm going to read it anyways, but you don't have to do that. It's specific with respect to the arguments that I've heard today by counsel on these particular charges, and that's something that could only help the court if you choose to want to give it. But I'm not ordering anybody to provide additional briefing on this motion. I'm just going to delay my decision until Monday.
Thank you, Your Honor.
So any questions from the defense about that, from the state?
No, Your Honor, thank you.
All right. And let's see. Do you anticipate, I think you mentioned was it Ms. Brown?
Yes,
Is that
Ms. Brown.
the next witness after lunch? Is that?
Right, but Your Honor, she's coming at 2:30. We could start with Sheriff Troyer when we reconvene and then interrupt his testimony, if that's all right with the court.
All right, so, yes, so with respect to that, and Mr. Troyer, I don't want you to respond to me, but there's a few things I need to say about your testimony today. And first, you have the right, a constitutional right to testify in your defense. You also have a constitutional right to not testify in your defense. The decision whether you should testify or not is solely up to you. The lawyers cannot make you testify or not make you testify. But it would be a wise individual that would seek the counsel of their lawyers in making such an important decision. And so I have no doubt you have spoken with your counsel many times about this decision, and I appreciate that it's been brought up now so that I can be assured that over the lunchtime now, you have additional time, if you want it, to speak with your attorneys about the decision whether or not to testify. When we come back, I'm going to, after lunch, I'm going to ask your counsel if they believe you need additional time to make this decision and allow them to say anything they want about that decision, but I'm not going to question you about that. This is individual privileged communication between you and your counsel, and I'm not going to ask you to say anything about that. So with that, well, anything else from the state before we recess? So with that said, we'll return at 1 o'clock to continue with the trial.
Your Honor, actually, if we could, Kim Brown will be short. Maybe we would have a longer break and then start with the sheriff after Brown.
Well, I'd rather start, if she's not ready till 2:30, I would like to use that hour and a half, and so.
Maybe jury instructions, I don't know, but I defer to the court.
Yeah, I would like to continue with the testimony portion of the case this afternoon.
Okay.
So, I hope I've been clear about this. I'm not ordering the defense whether or not to call Mr. Troyer.
Right.
That decision is his based upon his advice of counsel, and at 1 o'clock, the court will find out one way or the other how the defense wants to proceed on that.
All right.
All right. The court's at recess until 1 o'clock.
Thank you.